Yeah.
All right. So this is in the matter of the people of the state of Michigan versus Anthony Scott Haybecker, file number 2024-21819FH. I have Phoebe McClure appearing on behalf of the people, and I have Salvatore Malaro appearing on behalf of Mr. Haybecker. I did receive a letter, a victim impact statement in this matter. Did you receive that, Ms. McClure?
Yes, Your Honor.
And Mr. Malaro?
Yes, I did.
All right, and Mr. Malaro, could you move the microphone closer to you so we make sure we pick you up? All right, Mr. Haybecker, this is date and time set for sentencing in this matter. Have you had an opportunity to read and review the recommendation?
What? No.
No? Okay.
No.
Did you receive a copy of it?
Yeah,
I don't believe so.
Looks like we got it yesterday.
Okay, all right, so obviously we're not going to be able to proceed on this unless you have your laptop.
I do.
Do you want to go on back and Zoom with them?
Sure.
If you have time?
I have time.
Okay, all right, so Mr. Haybecker, Mr. Malaro, it's been a week here, so Mr. Malaro is gonna go, you can go this way. Right back here. Mr. Malaro is gonna go back, he's gonna zoom in, and then we'll put him in a breakout room with you, so he has time to speak with you, okay?
Okay, thank you.
You're welcome.
Your Honor, while we're in the break, I don't know, we never got what his jail credit was. I don't know.
Ms. Adams, did we get verification of jail credit yet?
Not yet. They said it might take a while.
Is that from the jail?
Yeah.
Okay.
Yeah, we called him this morning.
Yeah. I guess I thought that was something Mr. McLaren would do.
District court doesn't do that.
I didn't know that.
Not for us. I don't think they typically do that. Because they prepare these.
Yeah.
All right, so now I got Mr. McManus. All right, are you ready, Mr. McManus?
And on Mr. McManus's, Mr. McCready should be on Zoom for that.
Mr. McCready's on it, yeah.
I was gonna cover it, but then he said he could handle it.
All right. All right, and Mr. Mawad, you are like next, okay?
Oh, Judge, that's okay, no problem. I was just going to ask for a week adjournment. I wasn't able to talk to the client. After I saw you yesterday, I had to run to the hospital on a family member that's dying, but we can talk about
Oh,
the case.
no, I can call it if you're just asking for an adjournment.
Yeah, that's all. My apologies.
You mind, Mr. McManus? Okay. All right, so hold on.
I owe Mr. McManus a favor, Judge. I owe you a favor. Thank you very much. I just want to tell you thanks.
You can't owe me favors, so
all right. You know what I mean. Go ahead.
Okay, this is in the matter of the people of the state of Michigan versus Benjamin Kalen Wayne Scott. We have two files, 24-21932FH and 24-22089FH. This is the date and time that was scheduled for sentencing. Mr. Mawad is asking for an adjournment. I'm assuming Ms. McClure or Mr. McGreedy, you don't have an objection?
No objection.
All right, so Mr. Wayne Scott, just stay in the courtroom. We're going to get you a notice of hearing. Your attorney had a family emergency yesterday, so I don't know if I can do it next week, but Ms. Adams, when could I reschedule Mr. Wayne Scott?
We could do Thursday, March 19th at 8:15.
Yeah,
March 9th.
That's fine, Judge, and it'll give me a time to get onto Zoom with him and talk to him about the sentencing. That's fine.
Okay. All right, so we will adjourn this to March 19 at 8:15 in the morning. Miss Adams, I do have Mr. Wayne Scott here in person. Could I get a notice of hearing for him, please?
Yes, Jen.
All right, he is in the back of the courtroom with like a Madras plaid shirt on. Maybe not Madras, just plaid. Okay. All right, thank you. All right, Mr. Malaro, I'm gonna open up a breakout. You just stay right there and we'll get you a notice. Mr. Malaro and Mr. Haybecker, I am going to open up a breakout room. You'll get an invitation to join that breakout room. Can do that. And then, Mr. Haybecker, if you don't know how to get out of the breakout room, just stay there and I'll bring you back in. All right, join that breakout room with the mouse. Use your mouse, yep. There it goes. All right, so this is in the matter of the people of the state of Michigan versus Andrew Gordon Wright. This is file number 2025-22169FH. I have Mr. McManus appearing on behalf of Mr. Wright, and Mr. McCready, you are on this file. This is the date and time set for sentencing in this matter. Mr. McManus, you received a copy of the pre-sentence report.
We have, Your Honor.
All right, and Mr. Wright, have you had an opportunity to read and review it?
Yes,
Have you had an opportunity to discuss it with Mr. McManus?
yes,
Are you satisfied with Mr. McManus as your attorney and the advice that he's given you? All right, can you say that a little bit louder for us?
yes.
Okay, good. So, Mr. McCready, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Mr. McManus?
No, Your Honor, we have no additions, deletions, or corrections.
Okay. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not to my
Mr.
knowledge.
McCready? Mr. McManus?
Not to my knowledge.
All right, the probation department computed the minimum sentencing guidelines to be 12 to 24 months. Do you agree with that computation of guidelines?
People are not challenging that, no.
We agree with that computation, Your Honor.
Okay. Mr. McCready, is there anything that you would like to say on behalf of the people?
I know that Mr. McManus has submitted on behalf of Mr. Wright a couple letters, and I know he's asking for work release. And I did have a chance to look at that letter, and I believe that the probation department has verified his employment at a stone and gravel hauling company out of Saline that he's been at since, I think, 2017. My concern in that regard is that Mr. Wright has admitted also in the pre-sentence report to daily use of cocaine and methamphetamine as of January 1st, 2024, which would include probably 7 years during which he was working for that company. Which means that he very likely, or at least there's the possibility that he was using while on the job. At the very least, we know that he's got numerous convictions for operating, driving under the influence.
I'm going to stop you right there, Mr. McCready.
Sure.
Mr. Coast, could we test Mr. Wright today, please?
Absolutely, Judge. I'll be right in.
All right. Have a seat, and Mr. Coast will come and do a test. Thank you.
Thank you.
Thank you, Your Honor.
Right, it'll just be a few minutes. So the advice those, once I go through my spiel, then you can step down to them. So they did data and then, so that's it. But once I'm done explaining the rights to them, and then one copy, one they sign comes back to me and the other two they keep. Yeah. Oh, they come get them and take them. Like you would handcuff them, you call Justin, and then they come get them. And I usually set them over there after you handcuff them. But usually by the time you get them handcuffed, Justin's here. That's real good about it. No, Justin's good. Mr. McManus and Mr. Coast, could you approach over here? Okay. All right, so we'll go back on the record in the matter of the people of the state of Michigan versus Andrew Gordon Wright. File number 25-22169FH. Mr. McManus, Mr. Coast did have a test done and your client is positive today for cocaine. So obviously there's some very recent use because we know how long it stays in your system. So Mr. McCready, if you'd like to back up, start over and proceed, please.
Well, I mean, given that development, I don't know. So the agreement here is for him to do 215 days in jail. I would think that that should be, again, today, he should be taken into custody. And that, given that, I would say I'm opposed to any request for work release.
We don't have work release, Mr. McCready.
Oh.
We haven't had it in 10 years. So, when they closed, that place down. So, anything else, Mr. McCready?
No.
All right, Mr. McManus, anything you'd like to say on behalf of your client?
Your Honor, just, my client is 36 years old, he does have 4 children, he does have another, young child that he, just gave, significant other gave birth to.
Can you spit your gum out, please?
And like I said, he's the only provider in the home for that family and his children. We did make an agreement of the 215 days in jail, Your Honor. So we asked for to a minimum follow that recommendation. And we have nothing further. Thank you.
All right, so Mr. Wright, anything that you want to say on your own behalf?
I need a verbal answer, please.
I don't have anything to say. I would appreciate a work release, but you said we don't have it.
We don't.
So
We don't have that resource available. So, Mr. Wright, you know, you obviously have maintained employment for a long time, and you make good money. You got 5 kids now? 4? Okay.
3-month-old.
And a baby. So back in 11, you had a DUI with kids in the car. You driving with license suspended, operating under the influence, operating while impaired, leaving the scene of an accident, refusing the PBT, other operating with a high ABC causing serious injury, with a prior conviction. It's out of Lenawee. Domestic violence.
I have a pass.
Hold on, let me talk. Home invasion, this offense, right? So what I'm gonna say to you is, every one of these seems to me to be common to involve drug or alcohol use, right? So you obviously have a substance abuse issue, right? If I was the mother of your baby, I wouldn't want you around my kid because you use coke, right? And I'm talking, not you. So this is a problem because I have a lot of dockets, right? I have a recovery court program where I work with people who have addiction issues. I have an abuse neglect docket where I take kids away from people who commit domestics in their home. And then I take control of the kids. Like, your mom has been sober for 1.5 years, and now she has cirrhosis of her liver. She's on a transplant list. Your dad had substance abuse issues, and he died, he overdosed, and I'm sorry about that. So, you know, you have a family history with substance abuse, and I can only imagine what that was like growing up. And now you're gonna do it to your kids, and that's not fair. And I don't think you want that, because you always come in and you're a pretty decent guy, and you know, you acknowledge what's going on. Have you ever done inpatient?
Yes,
Did you complete it?
I did.
How long ago was that?
I did sobriety court for the DUI, IBAC with injury. I was here, I did sobriety court here 2.5.
You have a deep voice and it doesn't register in our system as well.
I'm sorry.
It's okay. Well, you apologize for your voice. How long did you maintain sobriety after sobriety court?
After sobriety court, 7 months.
Okay.
My mom's stuff happened and I started drinking.
Yeah. Okay.
Good dad though, I haven't been in trouble since, you know, this home invasion, I didn't invade.
Hold on. So this is kind of me talking, okay? Can I ask questions? We have the ability to release to inpatient, do we not, Ms. Holly? After a period of days, either through Mr. Coast's office or yours?
Sure, we can look into that.
All right, so in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. Sentence of the court that you'll be placed on probation for a period of 3 years. Is he eligible to be screened for recovery court?
I don't know. I don't know what their criteria is.
I don't know, but it's something we consider possibly in the future. So during that term of probation, you will obey and comply with all the articles of your probation. $750 court costs, $130 crime victim rights fee, $68 in state costs, $60 DNA fee. I didn't
I
see
think
rest.
that's already been, he's got previous files.
Oh, so we don't need the DNA fee. There was no restitution.
Not that I know.
Okay, I don't have restitution to order. There's a $30 per month supervision fee, 60 you have to put you on a tether. So, you know, Mr. Wright, I mean, your record's not good. But not the worst, but it's all related to substance abuse. So, I am gonna order, I would like to order work release for you with treatment and counseling. I really would. It was sad for the whole community when our work release program shut down because we lost that valuable resource. What, do you live in, what county you live in?
Wayne County,
You're in Wayne County, what city?
South Belleville.
Okay. So obviously I would prefer that, but I don't have that option at this point. And I think that, oh yes, is there a warrant with pickup? Where's that out of?
Yeah, I think that's here. I just was noticing.
Must have something in district court or
District
something.
court.
I don't know. So this is what I'm gonna do. I am going to order that you serve 6 months in Lenawee County Jail. I'll give you credit, or I don't think you have any credit. I will.
Judge, there was
Allow
a
you-
sentence agreement for 215 days.
Why does it say 6 months? Immediate, the prosecutor agreed to an immediate 6 months jail. Okay,
I can mention that, Your Honor. You want to make sure my client did the full 6 months
Oh.
and that he would probably get some credit in jail.
okay. So 215 days in Lenawee County Jail.
Thank you.
So, after 90 days, you could be released to an inpatient program. Your attorney can talk to Mr. Coast, but listen, if you leave that inpatient program, you get kicked out, then I can send you to prison and put you through boot camp or something. I'd much rather you get the help you need. And sobriety is better for your babies, your partner, and your family, okay? You do live in Wayne County, so, Ms. Holly, will you go to the jail and meet with them for transfer paperwork?
Yes, I'm gonna have to look into, I'm gonna have to talk to somebody about how to get him into some kind of program.
And Mr. Coast, I know, helps us too.
Someone over at the jail that does that too, I don't know.
Okay, so if you choose, you can go into an inpatient program, otherwise you're gonna serve the full.
I would love that.
Okay, so I will allow for that, and, you know, obviously I can't put you in my recovery court program, but, you know, you're 36 years old. Don't do to your family what your parents did to you, you know, and it's a pattern. I see it all the time. So, anything else, Miss Holly?
No contact with Joshua Slick.
No contact with that individual, Joshua Slick? Is that-
Yes.
Okay.
No weapons, search and seizure, all that.
Obviously, no alcohol, no illegal controlled substance use. Anytime you test positive, you can go to jail, right? And eventually, because your guidelines, you could go to prison. Now, anything else, Miss Holly, Mr. McCready? All right, so we are going to, and they'll do the paperwork to transfer your probation to Wayne County, okay? But if you violate probation, come back to me, right? Okay, so you do have the right to appeal this sentence. And in a minute, my bailiff's, not yet, in a minute, my bailiff's gonna hand you the notice of right to appellate review. We're gonna have you initial and date one copy for our records. The other two are for you. If you wish to appeal your sentence, you would fill out the information on those forms and get it to us within 42 days. You're gonna be at the jail, so you can just send it over with the kite, right? And they are gonna take you into custody today, okay?
Can I hug my baby one more time? If my mother-in-law brings her in. She's right outside.
Yeah, bring her in.
Thank you.
I would ask that he do it over there so it's not on camera.
Thank you. I really appreciate that.
Now, here's your notice of right to appellate review. Initial and date that were indicated. Today is March 13. I don't know if you have any personal effects you want to get rid of too. The jail can transfer that. So we're gonna have you step over there because I don't want this on
Okay, thank you very much.
camera. Record should reflect, I received back a signed copy of the notice of right to appellate review. Okay. Good luck to you.
Sorry. Thank you, Ron.
All right, Mr. Haybecker, we are back on the record. In the matter of, well, the state of Michigan under the file versus Anthony Scott Haybecker. This is file number 24-21819FH. Mr. Malaro, have you now had an opportunity to meet with Mr. Haybecker?
Yes, Your Honor.
Okay, Mr. Haybecker, you had a breakout room with Mr. Malaro, is that correct?
Correct.
All right, and did Mr. Malaro read through the recommendation and discuss it with you?
A little, yes.
Well, was it enough?
No, it's not, because I sent a kite out to one of the depths here, and I have the jail time that I've done here since July 18th of 23 to the moment. And that would be actually 271 days, far different than what you guys have me down for. Being that I've done 271 days of 305, which would be a county year with the 2 months good time deducted, would leave me with 34 days left to do. And I was asking, that's why I had spoken to Miss Fitzgerald, the caseworker here, and she told me that she had given Sal Malaro's office 3 weeks ago the dates that I was in the hospital from when I left here with a broken neck. And that was on February 22nd.
Mr. Haybecker, stop talking for a minute.
Sure.
Correct me if I'm wrong, but in this matter, that's not what I was gonna ask you anyway, but I was gonna ask you, you did talk to Mr. Malaro, right?
I did.
All right, Mr. Malaro, the recommendation on this is 1 year in jail, is that correct?
Correct.
And it also says he's got credit for time served.
So I don't understand if that means he's getting out today. No matter
Okay,
what.
all right, Miss Adams, any information from the jail yet?
Not yet, Judge.
All right, I'm calling the jail.
And if I may, Judge, I calculated 198 days.
Okay, hold on one second. This is Judge Anzalone. We called early about 8 o'clock this morning. We're trying to determine Mr. Haybecker's credit on a specific file.
Okay, I would actually need to transfer you down to the sergeant for that one.
Okay, thank you.
Yep.
So Mr. Haybecker had retained counsel, working over time, fired his counsel. Mr. Glazer had the case.
Sergeant Benward.
Hold on. Hi, this is Judge Angelina. I'm on the record right now in the matter of the people of the state of Michigan versus Anthony Haybecker. I know you guys are busy. I know we called around 8 o'clock this morning. We're trying to determine on a specific file what Mr. Haybecker's credit is.
Okay, which file was it?
It's 24-21819FH.
Okay, that is what I was currently working on right now.
Awesome, thank you.
Yeah, can I call you back in a little bit or?
No. I'll wait.
All right. Judge Angelina?
No, hold on, Mr.
So
Haybecker.
to finish, Your Honor, I inherited this case about
I understand that.
14 days ago.
Yes, sir.
I met with him at the jail last week for over an hour. I've tried to determine, I've reached out to Mr. Mawad. He did not have any time the days he was in custody with him. Looking through what I have, but Mr. Haybecker has 272 days. Based on his meticulousness, I have no reason to doubt it, but I can't verify it. And what he wants me to do is apparently something happened that he had to go to the hospital. I don't know how long he was there. I would have to get releases. He thinks I can do it in an hour. And if I could, I don't have an hour today. I have numerous sentencings. I tried to explain that to him. I just don't have it today, and I can't do it next week.
I understand.
So
I'm gonna try to resolve this.
Yeah, and my 2 cents on this is, and I don't know if Mr. Haybecker understands this or if the court agrees with me, but case law is pretty clear. If you're released to a treatment facility, I think whether that's rehab or physical.
There's no credit for
whatever,
that.
There's no credit for that. So when he went to the hospital, he's not getting jail credit for that. The jail released him at that time. And when he was incarcerated in Wayne County, he was on bond for our offenses. He doesn't get credit for Wayne County time. So I don't know if Mr. Malaro counted that in his credit or not, but whether Mr. Malaro figures out how long he was in the hospital or not, he shouldn't get credit for that.
Right.
and I did it, and I've explained that to Mr. Haybecker, but there's this gap with Mr. Mawad that I don't know.
Right, so the jail's gonna let us know how many days he actually spent at the jail.
Yeah, like I said, I'm working on it. That's gonna take a little bit, because it's not like I have a magic button approach. I have to look up every time he was here and count the days he was here.
Okay, well, I'll do another matter and then I'll come back to it when you're ready, and within the next 15-20 minutes, okay?
Yep.
Thank you.
Judge Angelone?
Hold on, Mr. Haybecker.
Okay.
Okay, so what we're gonna do is set this case aside for a moment. Mr. Haybecker, we're gonna let the jail do their count, and then we'll come back and discuss it in about 15-20 minutes, okay?
Okay.
Okay, so go ahead. I'm gonna release you and then we'll call you back in, okay?
Okay,
Okay, thank you.
thank you.
You can go.
That was Sergeant Benward. He can text me when it's ready to. So I'll let you know.
Okay. All right,
Yeah,
Ms. Morrow,
Yeah.
thank you.
All right.
All right, so I have Trent Baker.
Yes.
Mr. Noe, I will call over to the jail for Miss Wright. I think she's downstairs.
Thank you.
Hey, this is Judge Angelone. We are ready when you are on Erica Wright.
Yes, ma'am, give us just a minute, we'll get everything for you.
Yep, and then we have another pickup I guess we got another one, Mr. Baker. No. Who is it? Did we get another pickup? Paul. Paul? Oh,
Ms. Hall,
yeah, Angelina Hall. Oh, I gave you the file, and then I probably took it back. And then after Erica Wright, we also are ready for Ms. Hall.
okay, we'll do Wright and Hall for you.
Okay, thank you.
You're welcome.
All right, so I bring in Mr. Baker. All right, Mr. Baker, can you hear me?
Yes, ma'am. Can you hear me?
Yep, I can hear you.
Yes, ma'am. I'm 21 minutes away.
Okay, do you want to do it in person or via Zoom?
I would prefer to do it in person because that's what you wanted the first time. So I would like to,
Okay,
you know, if
all
that's
right,
okay.
so when you get here, just come up to the courtroom, okay?
I appreciate that. Absolutely. I just want to make sure I wasn't in trouble or anything. I had car problems. I'm so sorry.
Nope, you're good. Okay.
Yes, ma'am. I'll see you when I
We'll
get
see
there.
when you get here. Okay.
Yes, ma'am.
Mr. Malaro and Ms. McClure, can I talk to him back real quick?
Yeah, and I think for Mr. Baker, you just wanted him in person because he was young and you wanted him to see other sentencings, so. Yeah.
All right,
Trust me, I've had to sit and talk with him. No, I didn't, but I've had to sit and talk with him when he didn't have an attorney. It's miserable.
All rise.
All right, Miss Adams, any news from the jail? Miss Wright, can you hear me?
Yeah, ma'am.
Okay, so Miss Wright, sometimes the rooms downstairs have really bad audio, and that is not your fault. So if possible, scoot forward a little bit and just make sure you speak really loud for me, okay?
Okay.
All right. This is, you just don't even go near Sam Malaro. I know you're looking for him. Back up.
Oh, it's fine.
Okay, okay. So this is in the matter of the people of the state of Michigan versus Erica Lynn Wright. We have two files, 25-22217FH, and we have 25-22421FH. Now, Mr. Noe, you were her attorney on both of these. Are you still her attorney on these?
I certainly am.
Excellent. Mr. Noe, my office, we did notify you of this morning, and did my office email to you the motions, affidavit, and bench warrants?
Yes, I did get those. Yep.
Excellent. So, Miss Wright, we are here today on file number 25-22217FH on a motion, affidavit, and bench warrant, which alleges that you failed to appear for sentencing in a contempt of court hearing on February 27 of 2026. Now, that was a sentence, the initial sentencing on that. Mr. Noe, do you still have the PSI on that file?
Yeah. Pretty sure I checked my
Okay, good.
email. I'm pretty sure I do.
Okay, so Ms. Wright, contempt of court for failure to appear can carry up to 93 days in jail. Do you understand that?
Yes, ma'am.
Okay, and on file number 25-22421FH, there's a motion, affidavit, and bench warrant for failure to appear for a pretrial hearing on February 27 of 2026. Now let me look. Mr. Noe, I'm not sure. Now we have multiple failure to appears of your client, Mr. Noe. I have a failure to appear on May 21 of 25. I have a failure to appear back previous to, or what she did, turn this up in. We have a contempt of court back on, let me see, it was May 12, 25 filed, where she failed to appear, or she tested positive for THC and cocaine on April 14 of 25 with Mr. Coast. And then she just failed the drug test April 21, April 28, May 5, May 12 as directed. So, okay. And then the pretrial, I'm going to guess, but I'm not sure, on 25-22421 that maybe she pled on the other file, and that one was to be dismissed at the time of sentencing, and it was set for pretrial that day, but I'm not sure. So I don't know who the prosecutor was on that, and I know, Mr. Noe, you probably had the plea. I'm waiting for Miss Adams, if I could get a copy of the PSI. So contempt of courts, as I said, Miss Wright, do carry a maximum penalty of up to 93 days in jail. So Miss Wright, Mr. Noe is here, and you would like him to represent you today?
Yes, ma'am.
All right. Mr. Noe, would you like a breakout room with Miss Wright?
I certainly would.
Oh, well, maybe I got, no. Oh, yeah. You know what? Miss Adams did give me the PSI. I apologize. I should look better. So let me see what the plea was. Okay. The original plea case was, what was the original plea? Let me see. It does say that she pled guilty to count 3 on file number 25-22217FH on September 24.
Yeah, I don't think we have a resolution on this, on the newer file, Judge.
Very good. Okay, thank you. Thank you for clarifying that. All right, I'm gonna open up a breakout room and Miss Wright and Mr. Noe, go ahead and join that breakout room.
Thank you.
I can't get the pickup because I only have one jail window and just on floor one, Mr. Noe or Mr. Malaro. Okay.
I received a message.
Oh,
Jail credit.
we do have a message on jail credit. All right, let me get Mr. Haybecker back. Do you want to talk about that, Mr. Malaro, for a minute?
258.
No.
Hey, this is Judge Ann Sloan. I am ready for Anthony Haybecker.
Okay, I will call them, let them know.
And if you could let the sergeant know, thank you for calculating that for us.
Absolutely.
Thank you.
Thanks. Bye.
All right, and what was the credit you got?
258. So he'll, with a year, he'll only get 45 more days. Unless we can.
Thank you.
He gave me his release date too, if you order the 365. So if you want to look at that.
What would that be?
April 28th.
All right, Mr. Noe, let me close the breakout room, Mr. Noe. Mr. Noe, thank you.
No problem.
All right, so. Right, Mr. Noe, we are back on the record in the matter of the people of the state of Michigan versus Erica Lynn Wright, 25-22217 FH and 25-22421 FH. So, Mr. Noe, have you had ample time to speak with Ms. Wright?
Absolutely.
All right, and Ms. Wright, you've had a chance to speak with Mr. Noe?
Yes, ma'am.
All right, and are you satisfied with his advice and representation?
Yes, ma'am.
All right, and Mr. Coast, you are here on this as well, so I do acknowledge that. Mr. Noe, how would you like to proceed today with Ms. Wright?
Your Honor, Miss Wright, I did get a chance to talk to her. She did confirm we don't have a resolution yet on the newer file. So what I'd like to do today is plead her not guilty to the contempt, ask that be set for a hearing, and combine that with a pretrial for the other pending felony. That would be I think it ends in 2-1, I think, file number. And adjourn sentencing as well. Obviously, I don't want to proceed to sentencing in the other case today either.
Okay, Mr. Noe, I apologize for whatever reason with the jail on the first floor, we get a lot of feedback. And I don't know if they keep the door open. I don't know what it is. So, Mr. Noe, on 25-22421 FH, you want to set it for a pretrial?
Yeah.
All right, Miss Adams, I know we are overflowing next week. And I'm not sure about the week or two after that. When is the next day? I don't have a million pretrials.
Well, we've got 12 April 8th.
How about April 8th at 8:30 in the morning, Mr. Noe, on, that would be file number 25-22421.
Yeah, that'd be fine. What do you want to do with the sentencing, Judge? Do you want to adjourn that as well?
Do you want to adjourn it as well?
I think so, yeah. I think if I can
Okay.
combine this into one global resolution, I'd
All
prefer that, to tell you the truth. As opposed to
So I'm
keep
going to
going.
set both of these files to April 8th at 8:30 in the morning. We will set both, all the contempt of courts and the sentencing is for pretrial, but obviously we'll be back on that time. So anything else, Mr. Noe?
No, that's it. Thank you.
All right, Ms. Wright, we will see you back on April 8th at 8:30 in the morning with your attorney, Mr. Noe. Thank you.
Thank you, Your Honor.
Will you let them know, Ms. Wright, that I'm ready for Angelina Hall?
Yes, I will.
All right, thank you. Okay.
Thank you, Your Honor. Have a
All
good
right.
weekend.
You too, Mr. Noe. All right, I got the jail Zoom. Mr. Haybecker, if you are in that jail room, I'm gonna need to.
I think you had him leave the room.
Well, they just zoomed back in. I
Oh,
called
okay,
him.
I'm sorry.
But he's the jail Zoom that I have, not the one you're looking at.
Okay, sorry.
There's another one here that's muted and has no video. Which is why it doesn't show up on there. All right, Angelina Hall, can you hear me? Yep, good job. I'm muting. Thank you.
Do I hear?
All right.
Thank you. Okay.
Yep, this is in the matter of the people of the state of Michigan versus Angelina Ann Hall, file number 25-22152FH. Ms. Hall, we are here on a motion affidavit and bench warrant for failure to appear for a probation violation hearing on October 8th of 2025. The probation violation hearing that this is regarding is a request and summons for probation violation that was filed on September 18th of 2025, which alleges that you violated the terms of your probation and that on July 2nd of 2025, you were ordered to report to probation immediately following departure from Hope House Residential Treatment Program. And then you left against staff advice on let's see, September 12th of 2025. And were advised on that date to report to the probation department on September 16th, and you failed to do so. So, Ms. Hall, those were technical violations back in September, but over 90 days have passed. And so these are now non-technical violations. Do you understand that, Ms. Hall?
What? No. What's the
Yep,
difference?
I'm gonna explain that. So a technical violation means I can give you up to 14 days in jail. But after 90 days passes, I can give you a greater sentence or send you to prison. Do you understand that?
Yes, ma'am.
Okay, so Ms. Hall, you do have a right to have an attorney represent you on this and all subsequent hearings. If you can't afford to hire one, we will appoint you one at public expense. Would you like an attorney appointed to represent you?
I would, please.
All right, so do you want to zoom in with her real quick?
Sure.
Okay, and then I just, for the record, your client, Mr. Baker, is here, so.
Yep, I already reviewed the PSI.
Okay. So Mr. Baker, it'll just be a few minutes, all right? So give us just a minute, Ms. Hall, and Mr. Malaro is gonna
Thank
go
you.
connect to Zoom, and I'll put him in a breakout room with you. All right, I'm gonna step off the bench. Miss Adams, I need to step off the bench for just one moment. I'm gonna make you co-host. Could you put Mr. Malaro and Miss Hall in a breakout room, or
Okay,
you know how to do that? Yeah?
we'll find out.
Oh, never mind. He's here. I'm gonna do it right now. Okay. I got him. All right, so where's Mr. Malaro? Come on. Hold on. All right, Mr. Malaro, I'm gonna add you to, where are you? She's in jail Zoom. All right, sorry, Angelina. All right, there we go.
You're fine.
I'm gonna open up that breakout room.
Thank you, Judge.
Yep, thank you.
Doing well? Yeah, I'm doing okay. What about you?
Yeah, doing okay. Yeah.
Good.
All set? All right.
I'm still. Isn't he on one? Is he on two? Yeah. Number two.
Who? He's in the back in a breakout. He's in the jury room.
Thanks.
You're welcome.
All rise.
Okay, Mr. Malaro, let me bring your client back. All right. I was looking at your Zoom. Anyway, so Mr. Malaro, have you had a chance to speak with Miss Hall?
Yes, Your Honor.
All right, and Miss Hall, you had a chance to speak with Mr. Malaro?
Yeah, I guess.
Well, did you need more time to speak with Mr. Malaro?
No, I'm okay, Miss Angela. Thank you.
Okay, so Mr. Malaro, how would you like to proceed today?
Your Honor, I asked that the court, Ms. Hall will stand mute as to the allegations. of the violation and asked to set this over to Wednesday. This is Miss Underwood's case, actually her original case.
Okay. So, okay. Miss Adams, I know next Wednesday is like insane, like over 30 cases. Miss Adams, I think I have Miss Underwood next Thursday or Friday for sentencing. And didn't we send another one with Miss Underwood over on like Thursday or Friday of next week? Another,
Yeah, Thursday, March 19th at 8:15.
so Ms. Hall, I'm gonna enter a plea of not guilty on this. And I'm gonna set it over to March 19 at 8:15 in the morning. And then Ms. Underwood's really good about getting in contact with people in advance. It's been pretty hectic here lately. So we'll see you back on that day and she'll either talk to you before on that day, okay?
Okay, Miss Angelone, I was supposed to, you know me, I'm the worst person to self-sabotage and everything in my life, so I was supposed to be today, not turn myself in, but go to the women's domestic violence shelter in Ann Arbor. I also have been talking with Home and New Vision again, or not again, for the first time, to try to get out there, but I literally am trying to, I gotta separate myself from this area. And you know, I picked the worst boyfriends in my life, baby dads, that has ruined my life, but I'm the only one that can make it better. So I really was hoping to be able to go to this shelter. I don't know if I don't want to lose my bed, if anything, you know, and get closer to Washtenaw County, Ann Arbor. That's the best recovery community we can get, because we ain't got shit for here in town, excuse my language. And I gotta get away from here.
I know. And Miss Hall, I'm glad you recognize that. I know. I'm glad that you recognize that. But Miss Hall, we do have past incidents of some absconding, and this is another one. So I'm not going to release you today. Obviously, you know, you can discuss that with Miss Underwood. And we also have, at the time, if you plead at the time of sentencing, availability to help you find a place and things of that nature. So obviously we will keep that in mind, but I'm not going to release you on a pair bond today, okay?
Okay, that's fine.
All right, we'll see you next week, Miss Hall. Thank you.
All right, thank you, everyone. Have a good day.
You too. Thanks. All right. Well, I've got Mr. Haybecker. Mr. Haybecker?
Yes.
All right. So, Mr. Haybecker, the sergeant at the jail has worked hard this morning trying to calculate your credit for time served. So, Mr. Haybecker, I do not give credit for rehab or any time you're in the hospital. You only get credit for days that you were physically at the jail. So I'm gonna start with that. The credit we have for you for jail time is 258 days, which means if I were to sentence you to 1 year in jail, you would be released from the jail. Your out date will be April 28th. Do you understand that? Yes or no?
Yes.
Okay. The sergeant spent well over an hour going through your file, this file only, and looking at your in date, your out dates, and things of that nature. Anything you served on any other files where you had a bond on this file, you don't get credit for. Do you understand that?
I do.
Okay. Now, Mr. Haybecker, you were given a breakout room with Mr. Malaro. You spoke to him, and the issue we have basically is the credit for time served. So, Mr. Malaro, are you ready to proceed?
I'm ready, Judge.
Okay. So, Mr. Haybecker, Mr. Malaro did discuss the probation violation, or I'm sorry, it's a misdemeanor, pre-sentence report with you. Is that correct?
Yes.
All right. And were you able to ask him any questions he also met with you for like over an hour this week. Is that correct? Last week.
Yeah.
Okay. And are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes.
Okay, good. Now, Ms. McClure, before the court passes sentence, well, I guess I would ask, are there any, do you wish to explain or challenge the accuracy or relevancy of any information in this report?
No, Your Honor.
Mr. Malaro?
Judge, I did review the report, with Mr. Haybecker a little while ago. I put it up on the screen, went through both pages with him. I also reviewed the victim's impact statement with him as well. He did not indicate to me there was any errors or mistakes on the report.
Okay. All right. Ms. McClure, obviously we've received a victim impact statement, and I will read that into the record. Or no.
I can.
Okay, so Ms. McClure, we did receive a victim impact statement. Would you like to address it? Would you like to read it? What would you like to do?
Yeah,
Could you step up to the podium to do that, just so we get good audio?
Yeah, I'll just make a brief statement and then I'll read it.
Move the microphone, Ms. McClure, wherever you need it. Thank you.
Just on behalf of the people, Your Honor, we unfortunately had contact with Mr. Haybecker for a couple of years now, well, during the pendency of these cases. I would just point out to the court that through a review of his criminal history, he started out with relatively low level offenses and did some probation, but that was late 90s, early 2000s. And starting about late 2000s to current day, he's not successfully been able to complete a probation term, and he's done jail time or maxed out his jail time on each offense. He's also, as the court knows, not ever been able to successfully be out on bond. I think that would be the reasons for the sentence agreement that we made in this case. I would ask Mr. Haybecker to not have any contact with Ms. Bannon following this. He does still have a PPO in place. When this is over, the court won't have jurisdiction on the criminal case anymore, but there is still a PPO. I'd ask that he not seek her out, that he not have contact with her. Quite frankly, that he stay in Wayne County if that's where he's going to live, and not further aggravate the issue. I know part of Ms. Bannon's agreements with this plea agreement was that she didn't want to keep coming to court to see him. She believed that this was being prolonged so that he had the opportunity to see her in court. And that's again why she's not here for sentencing. So I will read her statement. Her statement was written directly to the court because she wants the court to hear it, and does not want to have any contact with Mr. Haybecker going forward. Ms. Bannon says that she has not felt safe since I first requested a protection order against the defendant in November of 2021. Since then, the defendant has filed multiple motions to terminate the protection order I have in place against him. As recent as the hearing, as the defendant's hearing in January 2026, he asked the judge to be bonded out on his personal recognizance so that he can be free to gather whatever information he needs to file another motion to terminate the PPO I have in place against him. The defendant has made it clear that he has no intention of stopping his attempts to contact me. The defendant's actions have affected my life in an extremely negative way mentally, in my relationships and my career. Since I feel I have no other choice, I plan to hide from the defendant for the rest of my life. My first step is to move, so as he knows where I live, I am not able to sell my home and relocate out of the area until later. For all the reasons stated above, I request the court to apply the longest sentence and probation for the charges which the defendant has pled guilty. Thank you, Ms. Bannon.
All right. Anything else? Ms. McClure? All right, Mr. Malaro, anything you'd like to say on behalf of Mr. Haybecker?
Judges, if there's a sentence agreement for 1 year with credit, we'd ask the court to follow that. I think this court is probably more acquainted with Mr. Haybecker than I am. I think he needs a lot of guidance going forward.
All right. Mr. Haybecker, is there anything you'd like to say on your own behalf?
No.
So, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. So Mr. Haybecker, in this file, you're originally charged with aggravated stalking, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine, which would have allowed the court to send you to prison or put you on probation for up to 5 years. The plea offer that was made in this file was for a misdemeanor stalking charge. Probation department out of district court has prepared the pre-sentence report. You reviewed it. You've had ample time to speak with your attorney. Mr. Haybecker, as I look at your record, and have dealt with you with regard to the PPOs, which are still in effect. The PPO is in effect, and I don't think it's
until 2027.
So it's in effect until 2027. Mr. Haybecker, I would advise you that if you have contact with her again, you'll be charged with stalking again. If you violate the PPO, you'll be charged with stalking again. And I will give you the maximum penalty of 93 days on that violation of the PPO, like we've done before. So it's very important that you understand that even though I don't have the ability to place you on probation, if you have any contact with her and violate that PPO, understand you'll be charged with stalking again. Do you understand that?
Yes.
All right.
Your Honor.
So,
did you already do the credit time served and all that?
no, hold on.
Okay, could you?
So it's sentence of the court that you will be sentenced to 1 year in the Lenawee County Jail. We will give you credit for 258 days that you've already served.
Judge, I don't think that's correct. That's what.
Oh, wait, we're
Mr.
getting
Van-
an update. What is the credit?
He just texted me
credit-
it was up.
Hold on. What is it, Sergeant?
On this particular charge, I had to cross-reference it to his original number, and he's only been here 194 days on this particular charge you're dealing with right now.
Oh, 194. Okay, thank you. All right, so I will give you credit for 194 days in Lenawee County Jail. Is he currently incarcerated on something else?
No.
I think he was held on other charges related to this. There was
Violation of PPO.
an 817 FH file, 818 FH file, and 819 FH file. The 817 FH file is what he was in for the longest.
Oh, so that's a different file. So on this file, Mr. Haybecker, now hold on and listen to me. We're showing that you only have because you had so many files, it gets hard to calculate. So on this file, I'll give you credit for 194 days, credit for time served. So you must serve the balance of the 1 year with whatever good time you get. If you believe that's wrong, obviously there's some internal process at the jail that you can question that, okay?
So Judge, I calculated 198.
And Mr. Malaro, going through your files, also came up with the number
Well, I had 198.
of 198. So,
I have no objection.
I'll give you the 198. So I'll add another 4 days. So I'll give you credit for 198 days already served, and then they'll have to recalculate your out date. Because you're maxing out, I can't give you a term of probation. And I will order that you pay $68, or wait, it's, misdemeanors are $50 in state costs and a $75 crime victim rights fee. You had your hand up, Mr. Haybecker?
Yes, all my cases regarding in respects to Mrs. Bannon are all together. And we're coming up with two.
So Mr. Haybecker, hold on.
Right.
Even though, listen to me, even though they all involve the victim in this matter, If you had a cash bond and you had bonded out on mine and you got arrested on another file, you don't get a credit on mine. You only get credit for files that you had no bond on or you had a posted bond. As I said, if you feel that this is not correct, you can ask for an audit of your credit through the jail, all right?
And for the record, this file was different because it was charged in January of 2024, or he was arraigned in January of 2024 for contact he had with Ms. Vanderwall, who was in the jail on a different file. So this credit didn't start until it was charged or he was arraigned on it.
Yeah. Okay, now we're gonna send over to you your notice of right to appellate review. There's gonna be 3 copies the jail's gonna give you. 1 copy, they'll show you need to initial and date it, okay? They're gonna send that back to me to go in my file to acknowledge you received your appellate paperwork. If you wish to appeal your sentence, you would just, what's the appellate time review on a misdemeanor? Yes, is it still 42 days?
Yes.
Okay, so if you wish to appeal your sentence, you would fill out the other paperwork and mail it back or send it over from the jail within 42 days, okay?
Yes.
All right, thank you. You're all set, Mr. Haybecker. I believe, Mr. Morrow, that leaves us with Mr. Baker. This is not a hider or anything like that.
No, it's just a misdemeanor, Your Honor.
All right. Okay, so, Mr. Baker, have a seat there. Mr. Baker, this is in the matter of the people of the state of Michigan versus Trenton Daniel Baker, file number 25-22487FH of Salvatore Malaro appearing on behalf of Mr. Baker, and I have Phoebe McClure appearing on behalf of the people. The court has received a copy of a pre-sentence investigation. I showed it was emailed to the prosecutor on March 10, and Mr. Malaro, you received it as well?
Yes.
All right, have you had a chance to discuss it with Mr. Baker?
Yes, Judge, I talked to Mr. Baker yesterday over the phone and reviewed it.
Okay, so Mr. Baker, you've had ample time, and make sure you speak loudly. I don't know if the microphone can be pulled up. Our audio in this courtroom is atrocious. So, Mr. Baker, you've had a chance to review the pre-sentence investigation?
Yes, ma'am.
And you've had an opportunity to discuss that with Mr. Malaro?
Yes, ma'am.
All right, are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes, ma'am.
All right, Ms. McClure, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
All right, there are no guidelines because there was a misdemeanor plea. All right, Ms. McClure, is there anything you'd like to say on behalf of the people?
Yeah, just briefly, Your Honor. Mr. Baker and his brother obviously got into an argument, which didn't seem like it was anything new for them, kind of not out of the ordinary. Unfortunately, though, Mr. Baker did make the decision to pull out a firearm during that altercation. I think he's taken accountability for that. He's agreed to forfeit that firearm. He's been on bond for this for approximately 6 months. And I know they're recommending just fines and costs, but just given his age and the nature of the offense, I would ask the court to consider placing him on another 6 months probation. So you would have a total year of supervision total from the time of the offense. I know his brother.
Would that be a deferred?
Pardon?
A deferred?
A deferred.
Oh, I'm just asking. Okay, I thought maybe you were asking to do that to give him a delayed or deferred.
No, just so he had some supervision. I wouldn't defer this only because it was a felony firearm charge that was reduced to a misdemeanor firearm charge. But again, I've spoken with his brother. It looks like the probation officer also spoke with his brother and, agrees that they fought all the time and, while he agrees his brother shouldn't have grabbed a gun, he doesn't want like a felony or anything like that following him. And he just wants to move on. But I do think, given his age and the nature of the offense, that some extra supervision would be appropriate.
Okay. That wasn't part of the agreement, all right?
Pardon?
That wasn't part of the agreement.
There was no sentence agreement
Okay,
made in the
okay.
case, they're just recommending finding
Okay,
costs.
okay.
Yeah.
All right.
Don't say sentence agreement with any forfeit right on, but that's happened, so.
Okay. He was charged with carrying concealed and blunt assault.
Correct.
You said felony firearm?
Just a felony firearm charge was all I meant,
Okay,
like a felony charge that involved a firearm.
Okay, thank you. And is this like expungable later if he never gets in trouble?
It is, Your Honor, and he could have been charged with felony firearm.
Oh, I know,
Would have
I
been
know.
2 years in prison, but yes.
Okay, but it's expungable.
Correct.
Good. All right, Mr. Malaro, is there anything you'd like to say on behalf of your client?
Oh, Judge, Trenton's very young, and completely accepts and understands that his behavior was inappropriate, even though his brother, and him got an argument, and a fight. He knows he handled it differently. I will say this, Judge Trenton has, from day one, taken this extremely serious. He has maintained regular contact with me. He's been on 6 months of probation. He was living with his grandparents. His grandfather constantly made sure everything was going, they were following all orders. Trenton would ask me questions about, hey, can I go do this? Hey, can I do that? And I'm like, you got bond conditions, you have to follow your bond conditions. And this is my knowledge, he did every single time. He followed my advice, Your Honor, and he took an anger management class, which is reflected in the pre-sentence report. The brothers, his brother recognizes that this was handled inappropriately, and that he just wants to go back to being brothers. I think the online management, anger management class that Trenton took properly addresses the behavior that he engaged in. Again, Judge, even up to today, he left a message last night about being here on time. He called me this morning. He zoomed in and then even, came down here. Though I understand Mr. McClure's request, I think he's already demonstrated he doesn't need supervision. He's moved past this. It's inappropriate behavior he engaged in. And so I'd ask the court to follow the recommendation. I think Mr. McCarron went into great detail, both in his assessment and investigation as to what would be the best recommendation here. I think the recommendation is completely appropriate. He does not live in Lenawee County. He lives, you still live in Livonia? You live in Livonia or Plymouth? Excuse me, Plymouth.
Yeah,
So he's not, I think your brother lives down here still. Yeah. So even though I think they got probably a lot of work to do to repair the relationship, they don't live in proximity to each other. So I would ask the court to follow the recommendation.
So, Mr. Baker, why did you have a gun that day? I mean, you don't have a concealed weapon permit, right?
No, ma'am.
I mean, were you carrying it because you didn't feel safe, because you thought it was cool?
I was carrying it because my 25th birthday, I went to go see my friends and I bought it for my buddy.
Okay. Okay. Anything else you want to say?
No, ma'am.
So, in determining the appropriate sentence in this matter, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for the law, and the protection of society. So, Mr. Baker, the probation department did have a thorough conversation with you. It does appear you're very open You mentioned you were very remorseful with the officers, you were embarrassed. You took a 16-hour online management course after that, so that's great. Most people don't do that. You and your brother have a tumultuous relationship. I have 3 boys, so I know what that's like. And you guys fought a fair amount, but you know, when you're around people, when things like that happen, guns can make bad decisions, right? Okay. Both of you are very honest about everything. You have no prior convictions. You make good choices. You've been on bond. Let me see, the date of this incident was September of 25. You were charged in December, I think, and arraigned. And it appears October. So it appears that since then, you've been making good decisions. You live in Wayne County. Plymouth is Washington or Wayne? It's like right there.
It's Wayne.
Yeah, I know. Okay. And so I understand your desire for probation for a period of time, but I feel like he lives out of county. He's been on bond for over like 6 months. He's done all right. I don't foresee him getting in trouble again. I hope.
This life is not for me, Your Honor.
No, did you do any jail time?
Like a night, a day.
Yeah, that's enough, right?
Yeah, it was enough.
The smell. Yeah, yeah. So I am not gonna place you on probation. This 5 years from today, you will be able to expunge this. I think it's at 5 years for misdemeanors.
It's 2.
2.
I don't know, Your Honor, but it changed, so I don't know.
I don't do misdemeanors most of the time because this is felony court, so Miss Spade might know.
I think it's 2 from when he completes whatever
Probation.
sentence you give him. So if you
Yeah.
finds a cause, once he pays that, I think that's what 2 steps.
So then you will be able to petition to get your record expunged here. And I think go online, there's resources for that. So. I'm working. Are you working?
At the moment, no, ma'am.
So you haven't been working since you lived in Texas. This said you haven't had a job since you lived in Texas?
No, I haven't had a job since 2015.
Right. Your last employer was in Texas?
No, it was Alabama.
Alabama?
Yeah, I worked on a military base, MDBS, worked as a commissary. I apologize.
Well, maybe they're based out of Texas.
So are you on Social Security or something?
No, ma'am.
So, and you haven't had a job since when?
2025, man, March.
Okay, okay. Are you looking for a job?
I thought you said 2015.
I did too, and I'm like,
No,
like
no.
9.
2025, but yes, ma'am, I am.
Okay, all right.
You can't go far in life without a job, so.
No, who's supporting you?
Who's supporting me? Thankfully, my grandparents.
Oh,
God bless. And I'm a very lucky guy. That's all I can say.
Okay. They're putting that, yeah, get a job.
Yes, ma'am.
Okay. All right. I don't know what fines and costs would be on this because they're not on my little list. So I know there's going to be $50 state costs. I don't know if there's a fine, but I'll do something else. All right. So $75 crime victim rights fee, $50 in state costs. I'm gonna do $100 law enforcement fee. And that's it. So you gotta pay $225.
500. It's in your name?
All right, so I'm gonna take it out of your bond. You'll get the rest of it. You paid a cash bond?
Yes, ma'am.
Okay. Your grandma paid a cash bond?
No, at that time I was working. I had a little job at the dispensary.
Okay, okay. So we're gonna take that and then you can probably go across the hall and try to get your bond back. I think that's how you do it, right? For district court?
Probably paid it down.
Well, district court, give me my money?
If that's where you paid it, yes.
Okay. All right, so we'll order that. You'll have to go down to district court. And I don't know if they'll do it for you today, but you can go down there and say the judge sentenced me and I'm supposed to pay my fines out of this and then whatever. So my assistant will do the paperwork. Now, you seem like a nice kid and you have someone here with you, so people must like you somewhat. So this is not the way you want to do it. Okay, so you do have a right to appeal the sentence, and my bailiff's gonna hand down to your notice of right to appellate review. You're gonna initial and date one copy for my records, just acknowledge you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the paperwork on the other two and mail it in within 42 days. I don't, it's a pretty good deal, so. For anything.
Mr. Baker can thank his brother and the officer for the
Yep,
plea offer.
yep.
What about the lawyer?
The officer.
Your brother and the officer recommended this reduction because of the fact that you were so remorseful.
And his attorney, Mr. Moore.
Yeah, so I wish you the very best of luck.
Yeah, I regret my decisions. I really do.
Okay, thank you.
Thank you, Your Honor.
Yep. And so remember, 2 years after that today, you'll be able to file for an expungement, all right?
Eat some food, will you?
Yeah, go have a cheeseburger. All right, the record should reflect, I've received back a signed copy of the notice of right to appellate review. Ms. Spade, I don't think you have anything else. So now I think they're all down there waiting for you.
Yeah, I'm sure they are.
I had to like wait because of the trial, so I figured I'd just keep it this way. So
right.
thank you.
Thank you, Judge.
Good luck. All right, Nolan, and well, I got both interns today. You guys have a good day. I'm done for the day.
Have a good afternoon.
You too.
Have a good rest
Bye.
of your day, Judge.
Yeah, bye.